Great. And one of the reasons I went down the road for the introductions is to challenge Joe Syke, who's been doing a great job for us back there with our AV stuff. Give Joe a big hand. All right. So the first two speakers, including me and Joe Cook, are going to talk about the economic side of some issues that involve a lot of litigation these days. And it's really not being set up in terms of the kind of a controversial point-counterpoint position. I'll try to give you a very balanced presentation of what's going on in this area. So my first area is the reverse payment settlements of pharmaceutical patent litigation. And this is an area that's actually a pretty hot area in Washington these days. Some of you may have seen some of these cases. It's an area that really represents the interface of patent law and antitrust law. And there's obviously some tension between that because in the patent area, we grant monopolies to protect the intellectual property that's been created, that's embedded in the new products. And in antitrust, we're anti-monopoly. So you get this tension that comes up with this area. And this is an area where, with the reverse payments, where it's particularly acute. And frankly, it doesn't sound like an area where you'd want to be a defendant. It can really be made to sound pretty bad. A recent amicus brief filed for the Supreme Court's going to hear a case dealing with these issues. And a recent Supreme Court amicus brief filed for that case characterized the issue as following: whether an agreement by a patent owner to pay a potential competitor not to enter the market is illegal. Okay? Whether the patent owner can pay someone else to not come into the market when they perhaps had a right to do that. So it doesn't sound like a particularly good thing. I'm the person in charge of the market. I've got the property rights. I've got the intellectual property rights. Someone else, there's a procedure which I'll describe for generics to enter the market. As the patent owner, branded patent owner, can I pay them to go away, or at least stay away for a while? So it sounds pretty ugly. The question that we want to talk about is it really that bad? Are there two sides to this issue that can be discussed? And we'll try to work our way through to that. So the background on this, we had some discussion of the HatchWaxman Act as we've worked through the panels over the last couple days. And one of the aspects of HatchWaxman is how generics can enter the market without having to go through the entire FDA approval process. So basically, if they have the same drug that's been patented, when are they able to enter the market, and can they enter prior to the expiration of the patent? And so there's this abbreviated new drug application process, and basically a generic manufacturer would file the application and certify that the branded company's patent rights do not prevent it from entering this market. And the idea is to streamline the process for them to enter the market. There's what's called a paragraph 4 certification that the patent is invalid or would not be infringed by the entry of the generic. And this process sets up a procedure which then gives the branded patent holder standing to sue for infringement, which would stay the generic's entry for 30 months. So this process is designed to put some order into what would be full-blown litigation if a generic entered the market and then there were challenges to it. So it's to provide some guidance to the generic as well as the branded company as we go through this process. Now the first generic applicants is granted a 180-day exclusive entry into the market. So it gives them a head start as being the first generic to come into the market, and a lot of money can be earned there because you're coming in on the tail of what had been the branded drug before. So that's a kind of an opportunity to encourage the entry of generics as opposed to have a full-blown race out of the bat. Now how these reverse payments work is following up on the HatchWaxman procedures. The generic drug maker files the abbreviated form and provides the certification alleging that the patent is not valid. And then the patent holder sues for infringement. So that triggers the 30-month stay. Now, sometimes there can be true questions about whether or not the patent is valid or not. But we've got this 30-day stay. There's perhaps a lot of uncertainty surrounding this, and the parties may settle agreeing to a payment schedule, which, as we'll see when we look at some of the cases, can be quite large amounts of money at stake here. So it's a payment by the branded manufacturer to the generic in exchange for the delayed entry by the generic. So they're, as stated in that amicus brief I mentioned, you're buying off a potential competitor, paying them not to enter the market. And that sends off alarm bells in the eyes of a lot of antitrust enforcers that, oh my gosh, we've got someone who dominates this market. There's a potential way for a generic to enter. We're going to pay them not to enter. So it sounds like, and take advantage also of the 180-day exclusive entry period. So it can set up a situation where it looks like there's a potential antitrust problem. And I'm going to talk about a few of the cases here, but the antitrust cases are oftentimes brought by the government. For example, the FTC, as we'll see, is very aggressive in attacking these types of activities. I need to, okay, typical reverse payments procedure. I'm reading my notes and not showing them to you. So, okay, there we are there. Okay, let's take a look at, we're going to look at a few cases here. This is one where the case, the action was found to be a per se violation of the antitrust laws. And for those of you who don't have an antitrust violation, there's basically two approaches to determining the illegality of a challenged act. One is it's an act that's viewed as so anti-competitive on its face that if the act itself is established, then it's viewed as per se illegal. Then there are other activities where there's a balancing test called the rule of reason, where the cost and benefits of those actions are balanced against one another. And the court's gone through a lot of activities where they put some activities in per se illegal, some they put in rule of reason. So this case involving Hearst-Mayer and Searle was decided in 2003 in the Sixth Circuit and came up with a per se illegal result. They went through the HatchWaxman procedures, and HMR sued for infringement, and the settlement was $10 million per quarter to not enter the market before a final ruling on non-infringement. And a key factor in this settlement was that the agreement did not settle the underlying patent litigation. So it was basically, we're not going to decide this issue, we're just going to pay you to go away for a while. And so if you look at the way it's set up is that the agreement stays the patent litigation, stops the patent litigation, but delays the beginning of the 180-day period. So this looks like a very exclusive type of an arrangement that's set up here, and maintaining the patent rights regardless of whether or not they're actually valid or not. And the Sixth Circuit held that to be a per se violation of Section 1 of the Sherman Act. And the language going along with this, but is enough. I need to keep on the schedules that I set for everyone else. Another case dealt with the rule of reason in the 11th Circuit. This is where Shearing settled patent litigation with two generic manufacturers, agreeing to generic entry dates in the future and also agreeing to make reverse payments to them. And there's, again, some big dollars here, $60 million to one company and $15 to another. The generic companies also licensed certain technology and products to Shearing under the agreement. So there was more than just kind of what looked like a pretty naked agreement in the per se case that we looked at earlier. The court decided to apply a rule of reason, and they balanced the various factors here, including the actual exclusionary power of the patent based on at the time of the validity of the patent at the time of the settlement, the extent to which the settlement agreement exceeds the scope of the patent, and resulting anti-competitive effects. And the court went through and balanced these out and found that at the time of the settlement, the patent holder could lawfully exclude the generics from the market. So they really, by going through this transaction, were not exceeding the authority they already had under the patent. So they weren't extending the market, extending the time of their patent. As a result of this, they were just getting the license, the litigation to go away. In the next case, in the Second Circuit, where we went through the beginning, same process, and there was another agreement that was signed here and Barr, the generic company, agreed not to sell the drug until the expiration of the patent, which sounds like, well, you know, if the patent were valid, that's not an agreement of anything new. So the court again went through the rule of reason analysis here, rejected the per se, and said that, laid out the standards for reverse payments could be legal under the following condition: the patent litigation is not a sham or otherwise baseless, and the scope of the settlement agreement is limited to the patent claims and terms. So they're trying to say some balances here. They could, so not to go too far with that. So they actually did not go into determining the validity of the patent in that case. Next case, the Cipro case decided by the Fed Circuit last year. Bayer held the patent. Barr Labs filed again under the HatchWaxman procedures back in 1991. Bayer sued for infringement and settled on the following terms: Bayer would not sell the generic until 6 months before the patent term expired. So, hey, if they really have a valid patent term, they're actually giving up some of their patent term here. And Bayer would pay Barr $49 million upfront plus quarterly payments totaling $398 million. There's some big money at issue here. And the Fed Circuit, which is set up to deal with the patent side of the equation, not necessarily an antitrust court, held that the patent payment is not an antitrust violation within the exclusionary zone of the patent, provided the following issues are laid up there. So this was a rule of reason analysis. So in summary, okay, in summary then, we've got four really leading cases in this area where the Sixth Circuit has held the per se, and we've got a legal per se under the Second Circuit. A legal per se under the Fed Circuit means they're not going to actually get into the balancing if those other factors are met. And then a rule of reason under the 11th Circuit. So this is great stuff for those of you who like to see the Supreme Court resolve issues, and that's the case that I mentioned earlier, where the brief has been filed, which I'll talk a little bit about it at the end. So from the enforcement perspectives here, we have a split between the agencies as well. The FTC is, with the new chairman, John Leibowitz, is on a mission to knock out reverse payments. He thinks they should be per se illegal, and thinks that's one of the most important parts of his agenda as chair of the FTC. The Department of Justice supports a rule of reason analysis, says that there should be a balancing in these types of cases. So you don't see these things happen that often, where there's a split in the circuits and a split between the enforcement agencies. So it's been kind of an interesting battle as we watch this go through. So the question is, from an economics point of view, what should we be thinking about reverse payments? Where do we draw the lines there? Are they always harmful? Are they always positive? Should they be per se legal? Should they be per se illegal? Or should they be somewhere between the two? Well, one thing to point out is that these things actually take place fairly common in the large patent settlements. Both the branded companies and the generic can stand to benefit from these. Now, you know, that is not a defense of them to say that they benefit. I mean, from a collusive agreement, both parties can benefit from it. So it doesn't do any good to say they benefit. What we're interested in antitrust is kind of the consumer welfare standard. Are consumers made better off or worse off as a result of these decisions? One argument is consumers can, of course, benefit by generic market entry because prices fall dramatically. But if that's at the expense of eroding valuable patent rights that are valid, then that can undermine the incentives that are created by the patent system. So we need to balance getting lower prices versus having better drugs come through the pipeline over time. Okay, so now the branded company and the generic may agree to reverse payment settlement that provides for generic entry earlier than if validity were fully litigated. That is, if you spend all this time fighting through, you may not get to the end of the process until the patent is totally expired. And we saw in the Cipro case where they actually allowed for entry 6 months prior to when the patent was set to expire. So it actually negotiated the process of getting in there. It's also possible that the consumers may benefit more from the settlement than from the litigation. Litigation is incredibly costly and disruptive to the innovation process over time. So it's not just say there's reason to be skeptical of these deals from an antitrust collusive perspective, but there are also reasons to think about that these deals could be good. And that's where the court is basically been headed, the circuit courts that go for the rule of reason are saying we need to balance these things out. And it's very interesting when I talked with my friends who are and colleagues that are in the antitrust space that pay attention to these things, they are really disagree about this. The ones that are in favor of per se illegality, there are very few that are in favor of the extremes, but there's some that are in favor of the per se illegality and there's some that are in favor of the per se legal, but I would say most of them are, there needs to be a balancing, a consideration of the facts of each case, and that it's a real concern of litigation that would ban all per se, all of these reverse payment things would perhaps be result in more litigation and may not make things better off. One point about the cost of this, that reverse payment settlements permit small generic manufacturers to challenge the existing patents and gain the 180-day stay. If the argument would be that the smaller generics may not be able to play this game if the reverse payments are not possible, because it will require them to litigate the entire case, which is very expensive and may actually delay the entry of the litigants as part of this, of the smaller generics. I'm running out of time, and I've tried to enforce my own rules. So I think the point that I want to close with that deals with that the question is not clear. The way the 54 law and business professors had in their statement, again, about whether an agreement by a patent owner to pay a potential competitor not to enter the market is illegal. That is the question, but the question, the big policy question is whether it should be per se legal or per se illegal, or something in between, which would be the rule of reason. I think the smart money is probably on a rule of reason analysis of this if the court gets to decide it, but there's legislation, as mentioned in that slide, that could perhaps ban these payments altogether, and I think that would not be a reflection of the balancing of the economic costs and benefits of the situation. But it's got a nice populist ring to it. It sounds bad, which works well in the political arena. The hope from most policy analysis is that I talk to is that the court will get to weigh in on this before the legislation makes its way all the way through. So that's what I have to say about reverse payments. Hopefully I've tried to give you both sides of this. I'll turn it over now to Joe Cook, who's going to talk about some of the litigation dealing with the average wholesale pricing issues. That's a round of applause now.